Hello. Today we are going to discuss law enforcement agencies and custodial crime against men. A crime is any act or omission made punishable by law. Crimes are not only committed by the section of the people called the criminals, but crimes are also committed by the law enforcement agencies. When one talks about custodial crimes against men, naturally it will cover such acts and omissions made by the authorities against men when such men are taken and kept in their custody. The police is empowered by the Code of Criminal Procedure to take into custody a person who is concerned with commission of an offense. While such person is in their custody, many acts or omissions which are made punishable by the penal law of the land are seen to be committed by the law enforcement agencies. The law enforcement agencies are supposed to be the keepers of law, and law confers them with enormous powers. This is also true that when powers are conferred, they are often abused and misused. Such abuse of powers must be curbed, and the law relating to custodial crimes that are committed by the law enforcement agencies requires to unfold, keeping in the view that such unwanted acts or omissions must be checked by all lawful means to set an example that the arms of the law is very long, which can reach the police custody, and law enforcement agencies are not spared when they commit offenses. Custodial violence is a serious matter as it is committed by those persons who are supposed to be the protectors of the citizens. It is committed under the shield of uniform and authority in the four walls of the police station or lockup, where the victim is totally helpless. The protection of an individual from torture and abuse by police and other law enforcing officers is a matter of deep concern in a socialist society. In all custodial crimes, what is of real concern is not only the infliction of bodily harm, but also the mental agony which a person undergoes within the four walls of the police station or lockup, whether it is physical assault or rape in the police custody. The traumatic experience which a victim has undergone must be brought within the purview of law. The issue of custodial crimes involves the issue concerning police powers, including entitlement of monetary compensation to be awarded for infringement of the fundamental rights guaranteed by the Constitution of India and by the ordinary laws. Custodial violence is an infringement of human rights. The Universal Declaration of Human Rights, adopted and proclaimed by the General Assembly of the United Nations on the 10th of December 1948, declares at Article 5 that no one shall be subjected to cruel, inhuman or degrading treatment or punishment. This declaration was necessitated as custodial violence and the abuse of police power is not only peculiar in a particular country, but it is widespread. It has been the concern of the international community because the problem is universal and the challenge is global. To mention another two articles are under Article 3 of the Declaration, under which everyone has the right to life, liberty and security of the persons. And Article 9 provides that no one shall be subjected to arbitrary arrest, detention or exile. Under the Constitution of India, Article 21 is laid down that no person shall be deprived of his life and personal liberty except according to the procedure established by law. Further, under Article 20, Clause 3, no person accused of any offence shall be compelled to be a witness against himself. Under Article 22, an arrested person shall not be denied the right to consult and to be defended by a legal practitioner of his choice. Every person who is arrested and detained in custody shall be produced before the nearest magistrate and within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in the custody beyond the said period without the authority of a magistrate. These are some of the safeguards provided by the international law and the Constitution to a person with a view to protect his personal liberty against any unjustified attack by the state. Despite these mandatory declarations, the custodial crime continues unabated, as found reported in the law reports, which will be discussed later on. The statutory provisions relevant to custodial violence. In spite of the constitutional and statutory provisions which are aimed at safeguarding the personal liberty and life of a citizen, growing incidents of torture and deaths in the police custody has been reported in the law reports. Some punitive provisions are incorporated in the Indian Penal Code, which seeks to punish violation of right to life. Section 220 provides for punishment to an officer or authority who detains or keeps a person in confinement with a corrupt or malicious motive. Sections 330 and 331 of the Code provide for punishment of those who inflict injury or a grievous hurt on a person to extort information or confession in relation to commission of an offence. And Section 330 makes a police officer guilty of torturing a person during investigation, which is punishable under the Code. Under Section 166 of the IPC, whoever being a public servant knowingly disobeys any direction of the law as to the way in which he is to conduct himself as such public servant, intending to cause or knowing it to be likely that he will by such disobedience cause injury to any person, shall be punished with the simple imprisonment for a term of 1 year, or with fine, or with both. Under Section 166A is another stringent provision. Under this section, whoever being a public servant knowingly disobeys any direction of the law which prohibits from requiring the attendance at any place of a person for the purpose of investigation into an offence or any other matter, or knowingly disobeys to the prejudice of any person any other direction of the law regulating the manner in which he shall conduct such investigation, shall be punished with rigorous imprisonment for a term which shall not be less than 6 months, but may extend to 2 years, and shall also be liable to fine. These penal provisions mainly direct the police officers carrying out investigation of commission of offence, so that they may be kept within the limits set by the law on the pain of punishments. The judicial reaction in the case of custodial violence. Custodial violence was not only the newspaper heading reports, but also came to the notice of the Supreme Court of India around 80s. Rudul Shah versus State of Bihar, reported in AIR 1983, Supreme Court, page number 1086, was the first case in India in which the court endorsed custodial violence and awarded compensation by the writ court. Here, a convict lodged in the jail has served his sentence, but to the utter carelessness of the authorities, he was kept in the jail for innumerable years without any charge against him. This is utter violation of the right to life and personal liberty of the citizen without due process of law. There are many other cases which are reported and not only decided by the Supreme Court, but also by the various high courts, and the courts considered about the custodial violence caused in innumerable cases by the police. Finally, a landmark case which has been decided relating to custodial violence and set a trend in this regard, that is D.K. Basu versus State of West Bengal, the landmark judgment. D.K. Basu versus State of West Bengal was reported in AIR 1997, Supreme Court 610, was a case registered by the Supreme Court on the basis of a letter written to the Chief Justice of India by the Executive Chairman of the Legal Aid Service, West Bengal. The court considered it fit and proper on considering the importance of the issue raised in the letter regarding custodial violence and the deaths in the police lockups. It has been felt by the Supreme Court of India to be imperative to develop custody jurisprudence and to implement the concept of victimology by framing the modalities for awarding compensation to the victims for atrocities and the deaths caused in the police custody, and to provide for the accountability of the officers concerned, that is, police personnel who commit crimes but go unpunished. Custodial violence, including torture or deaths in the police lockup, strikes a blow at the rule of law. In all custodial crimes, what is of the real concern is not only infliction of bodily pains, but also the mental agony which a person undergoes within the four walls of the police station or lockup. Whether it is physical assault or rape in the police custody, the extent of trauma that a person experiences is beyond the purview of law. After review of the laws, the Supreme Court found that custodial violence and abuse of the police power is not only peculiar in this country, but it is widespread. It further observed that the power of arrest, interrogation, and detention has been streamlined in England on the basis of suggestion made by the Royal Commission and incorporated in the Police and Criminal Evidence Act 1984. And the incidence of custodial violence has been minimized there to a very great extent. Supreme Court further convinced that instances have come to its notice where a police has arrested a person without a warrant in connection with investigation of an offense without recording the arrest, and the arrested person has been subjected to torture to extract information from him for the purpose of further investigation or for recovery of the case property or for extracting confession, etc. The torture and injury caused on the body of the arrested person has sometimes resulted into his death. Death in the custody is not generally shown in the records of the lockup, and every effort is made by the police to make out a case that the arrested person died after he was released from the custody. The court further observed that any complaint against such torture or death is not generally not given in any attention by the police officers. No first information report at the instance of the victim or his kith and kin is generally entertained, and even the higher police officer turned a blind eye to such complaints. The court made further observations. Even when a formal prosecution is launched on behalf of the victim, no direct evidence is available to substantiate the charge of torture or causing hurt resulting into death, as the police lockup, where generally torture or injury is caused, is away from the public gaze, and the witnesses are either policemen or co-prisoners who are highly reluctant to appear as prosecution witnesses due to fear of retaliation by the superior officers of police. The worry of the court is expressed in the words, "How we check the abuse of the police power." The court further observed, transparency and accountability perhaps are the two possible safeguards which this court must insist upon. Attention is also required to be paid to properly develop work culture, training and orientation of the police force consistent with basic human values. The court pointed out that apart from the police, there are several other government authorities like Director of the Revenue Intelligence, Directorate of Enforcement, Coastal Guard, the CRPF, the BSF, the CISF, the State Armed Police, Central Bureau of Investigation, CID, Mounted Police, ITBP, which have the powers to detain a person and to interrogate him in connection with the investigation of economic offences under the Essential Commodities Act, Excise and Customs Act, Foreign Exchange Regulation Act, etc. There are instances of torture and death in the custody of these authorities as well. The court then came to the verdict that it is desirable that the officer arresting a person should prepare a memo of his arrest at the time of arrest in presence of at least two witnesses who may be member of the family of the arrested or a respectable person of the locality from where the arrest is made. The date and time of arrest shall be recorded in the memo, which must also be countersigned by the arrestee. The court issued requirements to be followed at the time of arrest in all cases till legal provisions are made in their behalf as preventive measures. The requirements are 11 in number and popularly came to be known as arrest memo. Over and above this judicial law declared, the court also insisted on prosecution of the erring police officers under the penal law of this land. So friends, let us conclude. In the study of the duties and responsibilities of law enforcement agencies and the crime against men, the law declared by the Supreme Court in D.K. Basu is a landmark judgment. The law was declared in the said case till legal provisions are made in their behalf. In response to the law declared by the Supreme Court, the Parliament of India has amended the Code of Criminal Procedure 1973 by the Act No. 5 of 2009, which came into force with effect from 2nd November 2010. Section 41B has been inserted in the Code of Criminal Procedure, laying down the procedure of arrest and duties of the officer making arrest. Thank you very much.